afternoon. Welcome to the Analyst. Today we'll be taking up 6 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll take up is related to the parliamentary privileges and the freedom of speech, as the Supreme Court is hearing several petitions questioning whether the legislative privileges can override the citizens' fundamental right to freedom of speech and expression. The second article is related to the parliamentary productivity, as the productivity of the Lok Sabha fell to just 15% in the monsoon session. 12 bills were passed, but only one bill was passed with a detailed debate, that is the anti-paper leak law. In the mains value addition section, we'll have a discussion regarding the recommendations of various commissions for the police reforms in India. Additionally, we'll take up 4 articles in the prelims pointer section, which will be helpful for your prelims preparation. The first article is related to the parliamentary privileges and the freedom of speech. The context behind it is that there are several petitions pending in the Supreme Court questioning whether the legislative privileges can override the citizens' fundamental right to freedom of speech and expression. Therefore, we'll observe the evolution of the parliamentary privileges, the status of the parliamentary privileges in India, the significance, the purpose of the parliamentary privileges, the challenges associated with them, and a few suggestions in this regard. This is important in GS2 under the topic Parliament and State Legislatures, Structure, Function, Conduct of Business, Powers, Privileges, and the issues arising out of these. Firstly, what are the parliamentary privileges? They are the privileges, the rights, the immunities provided for the houses of the parliament and its members to ensure that they can function independently, they can perform their deliberative functions, their legislative functions effectively. Therefore, they need to have certain immunities so that they cannot be dragged to the courts of law when they are merely performing their deliberative functions or legislative functions. Now, there are 2 distinct models that we can observe regarding the parliamentary privileges. One is the British model, another one is the French model. As there is a topic mentioned in the syllabus, the comparison of the Indian constitution with that of the other constitutions of the world. Therefore, let us observe how we are influenced by the British model of the parliamentary privileges. When we observe the British model, they have the freedom of speech. The freedom of speech which is provided for the legislators through the Article 9 of the Bill of Rights as early as 1689 itself. As the Article 9 of the Bill of Rights in Britain provided that the proceedings in the parliament, observe this phrase, there are 2 critical distinctions between the British model and the French model. In the British model, the proceedings in the parliament itself are immune. That anything which is said in the parliament, whether it is said by the members of the parliament or it is said while testifying by a witness before a committee, that also will be immune. They shall not be prosecuted based upon whatever they say, even the witnesses in front of the parliamentary committees. So they are accorded that freedom of speech, that immunity is there. Plus they have the contempt powers also, because if we observe in Britain, the early parliament that derives its history from being a judicial body, as the medieval concept was that the parliament is the highest judicial body there. Therefore, naturally, to protect its dignity, to ensure that it is able to function, the contempt powers were necessary. That was the medieval concept. Therefore, they have the broad contempt of powers, even today, the power to punish for their contempt. And the British model, therefore, has a significant influence over several countries. For example, India is influenced by the British model of the parliamentary privileges, New Zealand, South Africa, similarly USA also. If we observe US specifically, there is the Article 1 Section 6 of the US Constitution 1787 itself, which provides, for example, that there shall be no arrest of the legislators during their attendance. When the House is in session, during their attendance, they will not be arrested except on specific grounds which are also mentioned, that is treason, felony, and the breach of peace. Therefore, there are narrow grounds only based upon which they can be arrested during their attendance in the session. And each chamber additionally, they have the powers to regulate their business, conduct their business, and come up with the procedures as well as to ensure the discipline for their members. Now, when we observe the French model, There also there is the freedom of speech that is protected. For example, Article 26 of the 1958 French Constitution provides that no member of the parliament may be prosecuted based upon whatever they say in the French parliament. Observe here, it is specifically protecting the members of the parliament, whereas the British model is protecting the proceedings in the parliament. So the French model did not explicitly protect, for example, the witnesses in front of the parliamentary committees, although the later judicial decisions, the courts in France, they provided a similar level of protection even for the witnesses testifying, etc., and for the other officers, members, etc. as well regarding the proceedings in the parliament. Plus, the French model does not provide for broad powers of contempt, unlike the British model. The French also have the influence on other countries, for example, in Germany. The German basic law that provides under Article 46 that no court proceedings of disciplinary action shall be taken up while the house is in session. While a person says anything during the proceedings of the German parliament, the Bundestag, and Article 18 specifically provides that the taking away of the personal liberty of any member of the parliament can only be done after getting the permission of the German parliament, the Bundestag. Now, coming to the significance of the parliamentary privileges, why are they even needed? The purpose of the parliamentary privileges. Firstly, it is based upon the doctrine of necessity. Because if the privileges, the rights, immunities are not provided, they will not be able to perform their deliberative functions, because they can be then dragged to the courts of law based upon whatever they say in the parliament. For example, they can be challenged even on the grounds of the right to privacy or the right to reputation, even that somebody can drag them to the court of law based upon the alleged defamatory remarks, based upon alleged offensive remarks made in the parliament. Therefore, they need certain rights and immunities based upon the doctrine of necessity itself. Plus, they will be able to perform their functions if they do not have the burden of defending themselves in the court. Then they will be functioning, they will be saying whatever they feel is the righteous thing to say independently, and they will be listening to their conscience, and they will be able to hold the government also to account, because the parliament, the houses, they are also the forums for expressing the anxieties of the citizens, for bringing in the issues of public importance, the issues of national interest. Plus, it will ensure that the dignity of the house, the dignity of the legislature, the efficiency, the independence of the legislature is not impeded. And the motto behind it is not to protect the individuals from the due processes. For example, there are certain protections. For example, the arrest cannot be made when the parliament is in session for civil cases, etc. But these are providing occupational immunity to ensure that they are able to discharge their parliamentary functions. These are not providing personal immunity. The term that we can use is occupational immunity. Also, the parliamentary privileges ensure that the public interest takes precedence over the private interest. For example, if there are no parliamentary privileges, no immunities, no rights, then any statement made on the floor of the house can also be challenged on the grounds that it is harming somebody's right to reputation, it is invading somebody's right to privacy, etc. Therefore, the legislators need the privileges to ensure their own protection from being sued in case they are making statements in public interest on the floor of the house. Therefore, the public interest takes precedence. And when we have the popular sovereignty, that itself functions like a safeguard against the probable legislative self-dealing. The legislative self-dealing you can interpret as if the legislators are going for a legislation only for the protection of their self-interest or their self-aggrandizement, not for the public interest. But they will be dissuaded from doing so if they are going to face the mandate of the electorate every few years. Therefore, the elections themselves will function as a safeguard against the legislative self-dealing. Therefore, the privileges alone will not be able to protect the legislators. Plus, when there is a representative democracy, ideally there is a free mandate. In a free mandate, the representative, the member of the parliament, because they are elected, therefore they are representing not only their voter base, but they are representing every citizen in that constituency. Therefore, they are not tied to a party in the ideal situation, in the free mandate situation, because the very fact that they are elected, that itself gives them the legitimacy, and hence they are subject to only listening to their own conscience. But that is not the real situation. The reality is they have a bound mandate, because they need to also adhere to the directions of the party, because when you study the concept of the political parties, they are also necessary for the aggregation of the interests, for the articulation of the interests, etc. Therefore, ultimately, if you observe, there is a significance of the parliamentary privileges, but they also need to be limited. Therefore, they also need codification. Has it been done in the other countries? Let us first observe that it has been done in Australia and New Zealand. In Australia, they have the Australian Parliamentary Privileges Act 1987, according to which they have been divided under the category of actions which may be treated as the contempts. Therefore, the punishments will also be limited, that here there is a contempt of the privileges and it is subject to judicial review as well, on the grounds to ensure that the rule of law is not violated, plus it is not unreasonably restricting the rights of the citizens. Similarly, New Zealand tried to do it through the Parliamentary Privileges Act 2014, through which the nature of the privileges, the scope of the privileges and the extent of the parliamentary privileges has been defined. Plus, it is subject to review also, and that review is done by the House itself, the Parliament itself. It can review, it can make amendments regarding what are the parliamentary privileges and what are not. Now, let us observe the status of the parliamentary privileges in India. It is included under the Articles 105 and 122. For the state legislatures, it is under the Article 194. The Article 105 of the Constitution provides that there shall be a freedom of speech for the members of the Parliament, that whatever they say, subject to the rules and procedures of the House, whatever they say, they will be immune from being prosecuted against that, and no member of the Parliament shall be liable to any proceedings, any court for anything said or even any vote given in the Parliament. And even there is protection for any person who is publishing the proceedings, the reports of the House, provided that it is done under the authority of either House, the reports, paper, votes or the proceedings of the House. In other respects, it can also be codified by the Parliament. The Article 105 Clause 3 itself provides that the powers, privileges and the immunities of each House, the members, the committees may also be defined by the Parliament by law. Additionally, there is protection under the Article 122 also, that the courts are restricted from inquiring into the proceedings of the Parliament, that the validity of any proceedings in the Parliament shall not be called in question in a court of law on the ground of any alleged irregularity of the procedure, and no officer or the member of the Parliament who are responsible for regulating the procedures or the conduct of business, they shall also not be prosecuted on the ground if they are merely exercising their powers, and they shall not be within the jurisdiction of any court of law. Now let us observe what are the privileges available for the Indian parliamentarians. There are collective privileges and there are individual privileges. The collective privileges include the right of the House to publish the proceedings, allow the publication of the proceedings of the House, and they can also restrict the publication of certain proceedings if the secrecy is necessary in the cases. Plus, they have the control over the internal proceedings, that no external authority or courts can interfere in the regular business, as we observe through the Article 122, and they have the power to punish for their own contempt also. And this power to punish for the contempt is available against both the members of the Parliament as well as the outsiders also, in case there is a breach of the privileges or the contempt. Plus, they have the right to exclude the strangers. They right to exclude even the press as well from the proceedings, and therefore they can hold the private sittings as well. Plus, they have the authority to enforce the attendance. The authority to enforce the attendance of its own members, witnesses or officials, and they can make the rules regarding the regulation of their own procedures. There are individual privileges also provided for under Article 105, for example, that there is freedom of speech regarding anything said in the House, and the immunity from the legal proceedings, that there is no civil or criminal action taken up for their speech or regarding their votes in the house. Plus they have the exemptions from the arrest in the civil cases also, that during the session or 40 days before the session and up to 40 days after the session, they cannot be arrested in the civil cases, and in the criminal cases or the preventive detention, this is not applicable. There is exemption from the jury duty or the witness duty also, that is, while the parliament is in session, they are not obligated to appear in a court of law as a witness in any case. Now let us also observe a few judicial observations regarding the interpretation of the parliamentary privileges in India. One of the earlier cases was related to Anandan Nambiar. The Anandan Nambiar case, the court held that the MPs, they do not have any special status. They have a similar status just like an ordinary citizen. Therefore, they are also liable to be arrested, liable to be detained, or liable to be questioned even while the parliament is in session. But later on, in the Keshav Singh case, that was the case where a person has published a pamphlet criticizing a legislator of the Uttar Pradesh Legislative Assembly. There the assembly punished that person for the violation of the privileges and hence sentenced him to imprisonment. But two judges of the Allahabad High Court ordered his release. Those two judges of the Allahabad High Court were summoned by the legislature in Uttar Pradesh. Here the court held that the parliamentary privileges cannot override the fundamental rights. Therefore, even judicial review can be exercised. It is not beyond the scope of judicial review whether the legislative privileges have been exercised within the constitutional limits. Here the judiciary can decide. Subsequently, in the Searchlight case, that is the MSM Sharma versus Sri Krishna Sinha case, that was the case where the editor of the newspaper Searchlight published certain proceedings of the Bihar Legislative Assembly, including the remarks which were expunged by the Speaker of the Assembly. Here again, the court observed that there is a freedom of press to report the parliamentary proceedings, but it is subject to the parliamentary privileges. And it is also subject to the reasonable restrictions to the freedom of speech and expression, which is included within the Constitution under Article 19, Clause 2. Therefore, here it was held that the legislature has the right to prohibit the publications of certain parts of the debates, for example, the expunged remarks which were expunged by the Speaker of the Assembly. Then in the Raja Rampal case, the Raja Rampal versus Speaker of Lok Sabha, that was the case related to the cash for query scam. The MPs were held in a sting operation through the internal inquiry of the House itself that they were allegedly taking cash in return for asking questions in the House, and they were expelled. They challenged their expulsion. Here the court held that the privileges are not absolute, they are also not beyond the judicial review. And the judicial review can be taken up if the privileges have been exercised in a grossly unconstitutional or malafide manner. Although the court observed that the courts usually should adopt a hands-off approach, that it should not usually interfere into the proceedings of the parliament or the functioning as well as the exercise of the privileges. But if there is a grossly unconstitutional manner or manner manner in which they have been exercised, then the court can definitely judicially review it. Then in state of Kerala versus K. Ajit case recently itself, the ruckus caused in the Kerala Assembly, here the court observed that the privileges and immunities given, they are not gateways to claim exemptions from the general law of the land. Therefore, there cannot be immunity for vandalism done within the assembly itself. Now, what are the challenges associated with the exercise of the parliamentary privileges? One of the primary challenges is that of the scope itself. That we need to ensure that there has to be a balance between ensuring the independence of the legislators, ensuring that they are functioning with integrity without any fear. On the other hand, they are not misusing it like a shield. That the parliamentary privileges, they should not be misused like a shield from the accountability, from openness. Plus, it is having a conflict with certain constitutional principles also. For example, the equality before law, Article 14 itself, and because they are having certain immunities, certain privileges, therefore the immunity from arrest, for example, the immunity from being subjected to prosecution or the legal processes, etc., that is violating the right to equality. Similarly, it is also prone to misuse. For example, the freedom of speech is provided. The immunity is provided for anything said on the floor of the House, but it is misused to make inflammatory remarks, offensive remarks, or even false allegations, baseless allegations against others. Plus, there is need for additional transparency and oversight in the exercise of the parliamentary privileges, and it becomes challenging to hold accountable in case there is an abuse of parliamentary privileges. And if there is an abuse, if there is lack of transparency in the use of the parliamentary privileges, it may lead to a decline of the public trust in the legislative process itself, whereas public trust forms the backbone of the legitimacy. So what are the suggestions that we can give regarding the parliamentary privileges? Firstly, there has to be a responsible use, not a misuse, not an overuse. It should not be for personal gain or political gain. It should not be for making inflammatory remarks or false allegations. Plus, the rights of the others also has to be respected, and there should be transparency. The transparency in the use of privileges, and ideally the reasons should also be given. There should be openness, there should be honesty when there is a claim of the exercise of the privileges by the members of the parliament. Additionally, the parliamentary procedure should be followed to ensure that there is impartiality, there is fairness on account of the speaker as well, the presiding officer. There is a mains practice question also. Discuss the significance of the parliamentary privileges in India. Examine the major challenges associated with their exercise, quoting the relevant case laws. Please try to write it. The next article is related to parliamentary productivity. As the Lok Sabha productivity in the recent monsoon session fell to just 15%, the lowest point in a decade. 12 bills were passed in the session, but only one bill was passed with a detailed debate on the floor of the House. Therefore, we'll discuss a few facts regarding the declining parliamentary productivity since the 1950s, the reasons behind the decline, the consequences of the decline of the parliamentary productivity, and a few reforms needed in this regard. This is important in GS2 under the topic Parliament and State Legislatures, Structure, Functioning, Conduct of Business, Powers, Privileges, and the issues arising out of these. We can observe a little data first regarding the average annual sitting days. During the first term of the parliament, it was around 135 days. The 16th and 17th Lok Sabha, it has come to around 50-60 days. If we observe the budget session also, this year the Lok Sabha had a high productivity of 93%, but the discussion hours for the budget session has been coming down. From earlier, it used to be around 35 hours initially, but now it came down to less than 15 hours. And if we see the demand for grants in 2021-2022, 76% of the demand for grants were passed without any discussion. In the monsoon session 2025, last year also, if we compare, that time also the Lok Sabha had a productivity of 29%, the Rajya Sabha had a productivity of 34%, and the question hour had a lower productivity in Lok Sabha 23% and Rajya Sabha just about 6%. When we look at the 17th Lok Sabha from 2019 to 2024, the productivity was just about 47% as per the PRS legislative data. The annual sittings have also been decreasing. 1952 to 1970 it was around 121 days, and since 2000 it was just about 68 days. In the 16th and 17th Lok Sabha, the bills that were referred to the parliamentary standing committees were just about 20%. And 35% were there in the 17th Lok Sabha, where there was just less than 1 hour discussion before the passing of the bill as per again the PRS data. Plus, there has been no deputy speaker for several years. The post has been vacant. Also, the role of the opposition in India has stayed muted. For example, the opposition has decided the agenda, the business of the House for less than 10% of the House time, whereas the role of the opposition in UK is way more. For example, it decides the House agenda for about 20 to 25% of the House functioning time. Plus, no private members bill has been passed in India since 1970 as per the PRS data. On top of it, the number of ordinances that have been passed, they have been increasing. For example, from 2000 to 2010, on an average 6 ordinances were passed per year, but from 2014 to 2023 there have been 12 ordinances passed per year. Additionally, the delegated legislation has been increasing. It has increased 4 times. Therefore, it reduces the oversight capability of the parliament. Now, what are the reasons behind the decline of the parliamentary productivity? One of the primary reasons attributed is the PMO-led lawmaking. Therefore, there has been a reduced role for the other members of the parliament, as the bills are mostly government driven, introduced by the cabinet ministers, as more than 90% bills, they are government driven. Therefore, the opposition itself gets limited session time. Because it does not get the session time, therefore it uses disruptions as a tool to protest. For example, the disruptions related to the Citizenship Amendment Act, Hindenburg issue, or recently the anti-paper leak, etc. Therefore, it affects the productivity of the parliament negatively because there are too many disruptions. Hence, time is wasted. Plus, the speaker's decisions, speaker's rulings have also been partitioned allegedly, as in 2023 itself, there were more than 150 suspensions of the members of the parliament, as there was unruly behavior. And the committees' roles have also been diminished. For example, in the 16th and 17th Lok Sabha, just about 20% of the bills were referred for detailed scrutiny, detailed debate, examination by the parliamentary standing committees. Therefore, mostly the bills are passed without debate. Now, what are the consequences of the declining parliamentary productivity? One of them is that the accountability will be lesser because there will be fewer sittings, fewer debates, fewer discussions. Therefore, there won't be a detailed scrutiny of the bills passed in the parliament. Plus, the number of questions which will be answered during the question hour, etc., that will be lesser and lesser. Therefore, ultimately, there will be lesser accountability. Plus, the quality of the legislation, that will be poor, because the debates that enrich the quality of the legislation, because a diversity of the opinions will bring in the additional ideas that will ensure that there are no flaws, no lacunas in the legislation, and it will ensure that the voices of all the sections of the society are heard, the concerns of all the sections are heard. Plus, the public distrust may increase, because when the parliament does not function productively, the parliament's ineffectiveness may lead to apathy among the public, may lead to disillusionment. Plus, there will be more silencing voices, because if there is a centralized lawmaking, if all the bills are government driven, the role of the opposition is to ensure that there is a productive critique also, so that the quality of the legislations can be improved. Plus, we can see that zero private members bills have been passed in more than 5 decades. Therefore, at times when the bills are not passed because of the poor productivity or the time running out, at times the judiciary has to fill in the vacuum, and therefore it has to give the guidelines in case there is an absence of a law. Now, what are the reforms needed to ensure a better parliamentary productivity? Firstly, we need more scrutiny of the bills that are passed. For that, we can put in place a committee system. For example, at least 75% of the bills which are passed in a session have to be mandatorily sent to the parliamentary standing committees for a detailed scrutiny, detailed examination. Plus, the public consultation should also be done before the bills are introduced and passed via vote in the parliament, or expert consultations can be introduced. The exercise of the whip may also be limited. For example, it is needed for ensuring that there are not frequent defections and ensuring that there is a stability in the government, but it should be used either for the passing of the confidence motions or in case money bills are introduced as per the recommendations of the Law Commission of India, and whip should not be issued ordinarily otherwise. Therefore, the members of the parliament, they should also have more autonomy so that they are able to listen to their conscience and able to decide independently as per their conscience. Plus, we can also bring in a consensus-based approach. so that there are fewer disruptions. There can be an institutional dialogue which can be started. For example, having structured meetings, periodic meetings among the speaker, the prime minister, the leader of opposition, and all party meetings to ensure that the time is effectively utilized on the floor of the house. And there can also be a definite number of days where the opposition decides the agenda. The opposition days can be earmarked. Also, we can have a number of guaranteed sitting days. For example, in Australia has a statutory minimum of certain number of days. Similarly, we can also have 100 to 120 minimum number of days where the parliament has to function. Plus, we can have an exchange program. The MPs, MLAs exchange programs with the other countries so that they can also go there and learn the best practices, both procedural best practices as well as ethical best practices, so that we can bring in both quantitative reforms, the productive reforms, as well as the qualitative reforms in the parliamentary productivity. There is a mains practice question also. What are the reasons for low productivity of the parliament? Discuss its consequences on the governance and accountability, and suggest measures to enhance the effectiveness of the parliamentary functioning. Please try to write it. In the mains value addition section, we'll have a discussion regarding the recommendations of various commissions for police reforms in India. As the Supreme Court deferred the appointment of the next DGP of Odisha, as there were allegations that the guidelines of the Prakash Singh case were not followed. So let us first observe what are the guidelines in the Prakash Singh versus Union of India case. Here the court had observed that there should be the establishment of a state security commission. So there is no unwarranted interference from the political executives. Plus, this state security commission itself should go for the evaluation of the performance of the police officers. And the appointment of the DGP should be for a period of minimum 2 years tenure, and it should be done based upon the merit-based selection criteria. And the police officers on the operational duty, for example, the superintendent of police, the station officers, they should also have a tenure of minimum 2 years at one place. Plus, it recommended that there should be a separation of the prosecution function, investigation function, ensuring of law and order function, and the other functions in the police. It also recommended the establishment of a police establishment board, that if there are any transfers, postings or promotions for the below DSP level officers, it should be done through the police establishment board. And there should also be a police complaints authority, so that if there are any grievances, they can also be submitted to the police complaints authority. And there should also be a National Security Commission set up. The National Security Commission should be there to select the chiefs of the central police organizations, and their tenure, the chiefs of the central police organizations, their tenure should also be for a minimum period of 2 years. Now let us observe the recommendations of the other commissions for introducing police reforms in India. One of the earlier ones was the National Police Commission 1977 to 81. It recommended that there should be a standard operating procedure, a training process for the constables. It also recommended the establishment of a state security commission, and it assured a minimum tenure for the chief of the police. And it also recommended for the reforms in the internal management that we can also explore the commissionerate system. Then the Ribeiro Commission in 1998 recommended that we should have a police establishment board, which should recommend the transfer, promotion, punishment, etc. And it should not be done via the influence of the political executives. Plus, it recommended that there should be a police recruitment board also for the recruitment of the non-gazetted police officers. Then the Padmanabhiya Committee recommended that there should be the establishment of a police training advisory council. And an additional superintendent of police should be there for crime and investigation, and there should be a separate district police complaints authority as well, where the complaints can be lodged against them. And the Police Act Drafting Committee recommended that all the officers should have a minimum 2 years tenure, and the SHO should not be a person having below the rank of a sub-inspector, and the transfer should usually be prohibited. It should not be done except as per the law. The next article is related to the Comptroller and Auditor General. This is important in prelims under the topic Indian Polity and Governance, and also in GS2 under the topic Appointments to various constitutional posts, powers, functions and responsibilities of various constitutional bodies. First, let us observe the constitutional provisions related to CAG. It is provided for under Article 148. Article 148 provides that the CAG shall be appointed by the President under his warrant, under his hand and seal, and he shall be removed in the same manner just like a judge of the Supreme Court. The salary and the other conditions of the service for the CAG shall be determined by the Parliament by law. Additionally, the CAG shall not be eligible for further office under any government of the state or the government of India after he has ceased to hold the office of the CAG. Also, the administrative expenses of the office of the CAG, including all salaries, allowances, pensions, etc., they shall be charged upon the Consolidated Fund of India. The CAG is treated as the guardian of the public purse, therefore ensuring the transparency and accountability in the management of the public funds for both the center as well as the state governments, and therefore he is responsible for upholding the financial discipline and ensuring therefore a check and balance in a democratic system. Now, the Article 148 provides for the appointment, tenure, conditions and the independence of the CAG. The duties and powers of the CAG are provided for under the Article 149, that the Parliament shall prescribe the duties and the powers of the CAG, and he is also responsible for ensuring that the accounts are maintained in the form of accounts prescribed for as per Article 150, and he submits the report under Article 151, reports on the union accounts to the President, and they are then placed before the Parliament, and for the state accounts they are presented to the governor and then placed before the state legislature. The CAG also ensures under Article 279 the certification for the net proceeds. It certifies the net proceeds of the taxes and duties, which is final and binding. The CAG Act of 1971 prescribes for the duties, powers and the conditions of service, as per which the CAG tenure has been prescribed to be 6 years maximum or up to the age of 65 years, whichever is earlier, and he can be removed in the same manner as a Supreme Court judge, as well as the resignation can be addressed to the President. The service conditions for the CAG cannot be varied to his disadvantage after the appointment. The next article is related to Delhi Sultanate, as the revised history syllabus of the Delhi University has dropped the paper on Delhi Sultanate. This is important in prelims under the topic History of India. The Delhi Sultanate extends roughly from 1200 AD to 1526 AD, and they were due to the rulers of Turkish and Afghan origin invading India. For example, the Turk invader Muhammad Ghori against the Prithviraj Chauhan. The dynasties started with the Mamluk dynasty from AD 1206 to 1290, the Khilji dynasty up to AD 1320, the Tughlaq dynasty up to 1412, Sayyid dynasty up to 1451, and the Lodi dynasty up to AD 1526. Let us observe the administration, the central administration and the provincial administration for the Sultanate. The Ilbari Turks, the slave dynasty, carried out the administration mainly via the trusted slaves who had aided the Sultan to get the throne and the members of the royal household. Therefore, the loyalty was the primary criteria, the prerequisite for holding the high offices under the dynasty. The Sultan was functioning as the head of the administration with all the military powers, administrative powers as well as the legal powers vested under him. The Wizarat was the most important office after the Sultan. The Diwani Wizarat was headed by the Wazir. The Wazir was the Prime Minister, the general supervisor of all the departments. He was also overlooking the financial organization of the state, providing the advice to the Sultan, even checking the land revenue collections and maintaining the records of all income and expenditures, overseeing the charitable donations, for example, waqfs, inams, etc. In the central administration, there was a Diwan-e-Arj also. That was for the military organization, and it was headed by the Arj-e-Mamlik, who maintained the royal contingents, recruited the soldiers, ensured the discipline among the soldiers. Alauddin Khilji introduced the Dag and the Hulia system. The Dag, that is branding, and the Hulia, that is description system, and even the cash payment for the soldiers. But Firoz Tughlaq abolished it, whereas Muhammad Tughlaq then continued the Dag system. Under the regime of Sikandar Lodi, the Hulia system was referred to as Chehra. that description. Then there was a Naibul Mulk who was functioning as the deputy of the Aris, the head of the Diwan-e-Arj. There was a Diwan-e-Insha also headed by the Dabir-e-Khas. It was responsible for looking after the Department of Royal Correspondence. The Dabir formed the formal channel of communication between the center and the other areas of the empire, and also functioning as a private secretary to the Sultan. There was a Diwan-e-Riyasat. It was important during the reign of Alauddin Khilji, as it registered all the supplies of commodities and maintained standards in the market, for example, checking the weights and measures in the markets. There was a Diwan-e-Risalat. It was headed by Sadr-us-Sadr, who was also the Qadi-u-Mamlik, responsible for the administration of justice and even for religious matters. There was a Diwan-e-Mazlim. It was headed by Amir-e-Dad in the absence of Sultan. His function was to supervise the Qadis, Kotwal, the police, the Muhtasib, that is the executive officer who supervised and enforced the public morals and public conveniences. When we come to the provincial administration, the provinces, that is the Iqta, they were placed in charge of the governors who were called as Wali or Muktis. Later the provincial were partitioned into Shikhs. They were further administered by the Shikhdars, and the Fauzdars further assisted the Shikhdars in maintaining the law and order during the Tughlaq period. Then the Shikhs were also further partitioned into Paraganas, that is the local administration. Now what was the function of the governors for the provinces, the Iqtas? The governor was responsible for the collection of the revenue from that province, maintaining the law and order in that province. Also, it was also to ensure that the opposition to the central authority was brought under control and the central authority's powers are not diminished in that province, therefore maintaining a military unit also under the command of the governor. Whereas the Arij also helped the governor in maintaining these military contingents and fulfilling these military duties. A Sahib-e-Diwan maintained the financial accounts of the provincial income and the expenditure as well. The next article is related to the allotment of the party symbols by the Election Commission of India. This is important in prelims under the topic Indian polity and governance. What is the responsibility of the Election Commission of India regarding the allotment of the symbols? It is provided for under the Election Symbols Reservation and Allotment Order of 1968. It provides for the specification, the reservation, the choice and the allotment of the symbols at the elections for the recognition of the political parties. That the symbols can be either reserved or they can be free. For example, for the registered, recognized political parties, they are exclusive. For example, the recognized national parties, their symbols are reserved and the other symbols are treated as free. The Election Commission published the list of the symbols through a notification in the Gazette. Whereas the unrecognized registered parties, for example, the newly registered or the parties which are not able to secure enough percentage of votes to become recognized parties, they can choose from the free symbols, from the non-exclusive symbols, and every subsequent elections then these symbols are declared free again and a new party can choose them. Therefore, the unrecognized parties, they also have a choice to give names of 10 symbols in the order of preference that they want to choose out of the list of the free symbols. And as per the 1968 order, the election order, they can also propose 3 new symbols also. Then they will have to propose the name of the symbol, design of the symbol and the drawings, the clear design and drawings of the symbol. But they should have no resemblance to the existing reserved symbols or any of the free symbols. And they should also have no religious or communal connotation if they are going to propose a new symbol, or they should also not depict any bird or animal as well. Now the concerned issue is if there is a recognized political party which splits into factions, which faction gets to retain the symbol of the political party? The para 15 of the Symbols Order 1968 provides that the Election Commission shall decide on the claim of the rival factions and the decision of the Election Commission shall be binding. So what is the criteria for decision making to resolve the dispute in case of a split? 3 tests have been outlined in the Sadiq Ali case, which are followed by the Election Commission also, that there should be a test of the aims and objects of the party constitution. Based upon that, it will be decided which faction will receive the symbol. There should be a test of the party constitution and the test of majority. Which faction is having the majority, that faction will receive the election symbol. Now, if the Election Commission could not test the strength of the rival groups based upon the support within the party organization, Then they will test the majority among the elected MPs and MLAs, because each faction may have certain number of elected MPs or MLAs also. If both the legislative test and the organizational test, that is which faction is having more support, if both the tests are indecisive, then the election commission usually freezes the symbol and asks both the factions to choose a new symbol. The next article is related to the constitutional limits on arrest. This is important in prelims under the topic Indian polity and governance. There are certain safeguards provided when a person is arrested. For example, he has the right to be informed regarding the grounds on which he has been arrested. It is provided for within the constitution also under article 22 clause 1, and also section 50 requires it, section 50 of the CRPC, and now section 47 of the BNSS. The time of arrest should also be mentioned when the arrest memo is prepared as per the section 57 of CRPC and now section 58 of the BNSS. And when a person is arrested, he has to be produced mandatorily before a magistrate within 24 hours of his arrest, excluding the travel time as per article 22 of the constitution. And he has the right to be consulting a lawyer of his choice. He has the right to be defended by a lawyer of his choice, plus a warrant will be required for making an arrest in case the offense is a non-cognizable offense. That is, for example, a simple hurt, defamation, etc. For the non-cognizable offenses, the warrant will be required for arrest. Plus there is a protection against degrading treatment also, that they also have the right to dignity under the article 21. Now let us observe a few case laws in this regard. In the Vihan Kumar versus State of Haryana recent case, the court observed that it is mandatory to meaningfully inform the grounds for arrest. Therefore, the communication has to be direct. That the communication for the grounds of arrest cannot be to the relatives or it cannot be ambiguous. Rather, the arrested person must understand directly the grounds of his arrest, and therefore it sets a precedent for safeguarding the personal liberty and also ensuring the procedural fairness. The Arnesh Kumar versus State of Bihar case observed that there should be certain guidelines to prevent the misuse of the criminal laws and harassment. Therefore, the arrests should be an exception in the cases where the offense attracts a punishment of less than 7 years, and the continuing prosecution based upon false allegations, frivolous allegations, amounts to the abuse of legal process and violates the principles of natural justice. In the Menka Gandhi versus Union of India case also, the court had observed that Article 14 is antithesis to arbitrariness. It must be upheld, and therefore arbitrary arrest also violates the golden triangle, the golden trinity of the rights, that is Article 14, 19 and 21. Now let us observe the provisions regarding the detention also. There is a difference between arrest and detention. Arrest is formal police custody with a probable cause of offense, whereas detention is temporary hold for investigation without any charge. There are procedural safeguards for arrest provided for under Article 22. That is, they have the right to be informed, right to consult a lawyer, right to be produced before a magistrate within 24 hours. But in the case of preventive detention, the procedural safeguards provided for under Article 22, Clause 1 and Clause 2 of the Constitution, they do not apply. And the duration of the preventive detention can be 3 months, but there can be a further extension based upon the permission received from the advisory board. Thank you.